I forgot to turn on the recorder. So
Okay.
can you give me just one more minute, and then we have some other participants that are
You want me
waiting.
to go backwards?
Yeah, if you don't mind.
Okay,
Just
I don't mind.
let me, I'm going to admit the other people that are waiting. And I apologize. When I said we're ready, I didn't intend for you to start, to be honest. I meant to say that we are ready, as in I'm set up. I apologize for not communicating that better. All right, hold on a second. Let me make sure everybody else is in. Yes. Yes, I do. Yes, I do. Hold on a second. And Theresa, would you do me a favor? Would you allow Elizabeth to start off?
Oh, yes, absolutely. I am so sorry. When you said you're ready, I was like on it. I'm sorry, everybody.
I know.
You're good. You're good. Hi,
All right.
Christine.
Hey, Christine. Welcome.
Good morning.
Okay, I'm going to make sure that I'm recording. It says I am. So, yeah, we're ready. Go ahead, Dr. Elizabeth.
All right. Good morning, ladies. How are you on this beautiful, beautiful Saturday morning?
Wonderful, wonderful.
Everyone's doing good?
Yes.
Hey, before I go into my introduction, I just wanted to just kind of share, you know, yesterday we celebrated Juneteenth. And as Sacramento opens up, let's remember to buy Black. Let's remember that since March, we have been in you know, stay-at-home order and not really doing a lot of business. So now since we're opening, let's consider buying Black. Let's consider doing business with our African-American entrepreneurs. So with that being said, I just want to you know, kind of remind everyone the importance of buying Black, and you can review the website for various African-American entrepreneurs that's in the Sacramento area. So again, good morning and welcome, my coalition sisters, friends and family and guests. Sending greetings from the National Coalition of 100 Black Women, Sacramento chapter. I want to welcome everyone this morning to Will's Trust and Probate Workshop. I have to say this is, out of all of our 4 series, SisterNomics, in my opinion, this is probably the most important. Being able to understand the importance of a will. What is a will? What is a trust? And how does probate work? All of those things are so significant. In addition to that, wills and trust may help build wealth for that next generation. But before we begin the program, I want to just give you a little bit of history about the Sacramento chapter of the National Coalition of 100 Black Women. We're a nonprofit volunteer advocacy organization. We were chartered in 2001. We comprise of professional African-American women. We are dedicated to public policy, economic empowerment, education, and leadership development. The National Coalition of 100 Black Women, we are one of 61 chapters in 25 states, and that includes the District of Columbia. We have approximately 2,800 members working collectively in the community to provide knowledge and resources in the following areas. Economic empowerment, such as today, workshops on building financial, well, first financial literacy and building wealth, living trust, wills and probate, real estate and money management. On the health side, our initiatives are the metabolic syndrome, which is heart disease, diabetes and stroke, breast cancer, mental health, child obesity, and overall healthy lifestyles. In regards to education, we have a summer reading program, which will, our kickoff is today at 1 o'clock. We provide college tours, scholarships. We've partnered with Huntington Learning Center to provide free ACT, SAT course preparation. And we will begin our first STEAM program at Natomas Middle School in the fall. In regards to public policy, we focus on voters' education and registration, 2020 census, and we also provide a legislative day in the month of March. In terms of our fund development, we have an annual signature luncheon and our big day of giving. The National Coalition of 100 Black Women, some of our values are gender equality, inclusion, respect, racial and social justice, integrity, accountability, economic empowerment, and collaboration. And our last signature program is our mentoring program, which is called Fostering Hope. And this year they had a summit which they focus on Black girls and technology as well. And in that summit, the focus was to educate our young girls of the importance of the STEAM or STEM and coding career opportunities. I want to thank you very much. I want to thank you all this morning for attending this important workshop. Now what I'd like to do is turn the program back over to our first Vice President of Programs, Jennifer Willis. Thank you, everyone.
Good morning, everyone, and thank you so much for joining us. We appreciate it. I am going to ask everyone to please mute themselves, and I believe everybody is automatically muted, so you can unmute yourself by pressing the unmute button. Hopefully at this point we have both Theresa Geoffroy and I unmuted. And Theresa, you can take over control if you'd like.
Okay, bye-bye.
All right.
Good morning, everyone, and thank you so much for joining us today. My name is Theresa Carter Geoffroy, and I will be presenting wills, trusts, and probate to you. Just a little background. Before I went to law school, I worked at SBC Communication, and they had a program that would allow you to go back to school, and they would pay for your undergraduate degree. So I took them up on that, and I ended up getting my undergraduate from Stanford University. I went on to Santa Clara Law School, where I graduated with my JD, Juris Doctorate degree. I'm married to Garnett. Tomorrow we'll be celebrating our 23rd wedding anniversary. Yay!
Congratulations.
And I have been practicing law for 22 years this year. We live in Sacramento County. We've been here for about 19 years. We moved up from the Bay Area because my mom lived up here, and she was starting to get sick, heart conditions, etc. And I'm her baby. So of course I moved up here to take care of her. Well, unfortunately, she was stricken with stage 4 colon cancer. I still remember the day that we received that news. And like everything else in life, I developed a strategy and said, Mom, this is what we need to do. One of the first pieces of advice I told her that we should do is to prepare her estate plan. I told her what would happen to us if she didn't, that we would have to go through the probate process, etc. So reluctantly, even in the midst of her fighting this terrible disease, she prepared her estate plan. And I can tell you that from her disability, incapacitation, death, and the distribution of her assets was like a seamless transaction for my 8 brothers and sisters and I. We are still very close, almost 11 years later. It was no animosity. We knew what we were doing because we were following Mom's directions. And then throughout my grieving process, I started looking around at other people. What were they going through when their loved ones were stricken with either incapacity or death? How were they ending up in probate court, and what was happening to them when they ended up in probate court? I looked at their situations and I looked at ours, and it was like night and day. And so a light bulb went off, and the law office of Theresa Carter Geoffroy was born. My mission is to provide my clients with legal solutions for preserving independence over their long-term health care and financial decisions so that in the event of incapacity or death, their businesses and families can proceed in a reasonable and rational way. Now, I am a solo practitioner, but I belong to Wealth Counsel, and that is a group of individuals, of attorneys, CPAs, financial advisors, who kind of help each other. Even though I'm solo, I still have the access to legal minds. So if there's any, questions that I don't understand, I have access to people that can help me through the process. Today, we're going to talk about the top 5 estate planning mistakes. Now, usually this is pretty interactive. I usually ask you, the series of questions, but since we are on Zoom today, I just want you to think about the answers to the questions. So let's get started. The number 5 mistake is letting your family go to probate court. Now, we've all heard about probate court, I'm sure. There's the death probate. Now, death probate is the process of retitling an individual's property out of their name into the names either listed on a will or the heirs at law, the heirs that are determined by the court. Now, this process, there's 4 things that I do not like about this process. Number 1, it's time consuming. Number 2, it's costly. Number 3, it's public. And number 4 is court supervised. So let's just go over those 3 reasons. Time consuming. In Sacramento County, probate takes between 1 to 2 years. 1 year for a very simple probate. It takes, and now with the COVID-19, everything has stopped. So all of those probates that were going to go forward in March, April, May, June have all been pushed back to who knows when. So the pre-COVID-19 timeline was between 1 to 2 years. It's costly. It costs between 6 to 8% of your gross estate value to go through probate. So let's say you had a house, just a house, and it was worth $350,000. When you take all the different fees and a cost, it will cost your estate approximately $21,000 to go through that probate process. So that's pretty expensive. And so you can imagine if you add additional assets, how the probate costs will rise. It's public. As soon as you open a probate file, it lists all of the deceased person's name, their address, all of their assets. It lists their beneficiaries, their names, their addresses, their age. It even lists when the beneficiaries are going to receive the assets. I can go down there and look at your probate file. Your next door neighbor can go down there and look at your probate file. But more important than that, people go down there and look at probate files, combing those files to find potential victims. I say that if you let your family go through the probate process, it is like putting a red bullseye on their back. And the last thing that I don't like about probate is that it's court supervised. The court has to sanction sanction any activity, any action, either before or after that action takes place. So letting your family go through death probate is definitely a big mistake. Now, there's living probate too. I'm sure that you've heard of this before. Living probate is conservatorship, right? And just like I don't like death probate, I don't like conservatorship. I don't like conservatorship because the time conservatorship is even more than the death probate. Conservatorship starts when the person can no longer handle their legal affairs until they die. And we're living longer and longer with debilitating diseases such as Alzheimer's, Parkinson's, dementia, head injuries. And so for living probate, conservatorship can last years and years and years. And it is also costly. It costs between $10,000 to $15,000 from beginning to end of a living probate. And again, it's public. And this could be even more embarrassing for the family because it lists about the financial situation of the conservator, and also it lists why they're in the conservatorship in the first place, their private healthcare information. And then again, it is court supervised. And some people said, well, you know, maybe we can avoid the unwanted court interference, delays, expenses, and publicity by doing alternatives to court, such as wills, joint tenancy. However, those alternatives to probate court, to me, are probate delays. They're not probate avoidance. For example, a will is just really a ticket to a probate. A will says, this is what I have, this is who I wanted to go to, and this is who's in charge. But if it's over, if the combined assets are over $166,000, then it will take a judge to transfer those assets out of the deceased person's name into the names of the persons that are listed in the will. And joint tenancy, well, there's a couple of issues with joint tenancy. Now, I hear a lot of people saying, well, you know what, I'll just put my child on my property. And that will avoid probate, right? Well, there's a couple of things wrong with that. One, what if your child is sued, involved in some type of lawsuit? Well, your house that you just put their names on it can be at least 50% of it included in the lawsuit, right? Number two is, what happens if you become incapacitated and you needed that house sold so you can go down to assisted living or move or downsize? If you're incapacitated, that joint tenant cannot sign your name on that deed. However, they would have to go into probate court to become your conservator in order to make that transaction work. And then what happens if the joint tenant dies? After the joint tenant dies, it still may have to go through probate unless that joint tenant did their own estate planning. So joint tenancies and wills and the other probate avoidant tactics, they really are probate delays. They're not probate avoidance. The preferred estate planning vehicle, for most people, are living trust. So what is a living trust? Well, it's a legal document. It's very similar to a will. A will, like I said before, says this is what I have, this is who it's going to, and this is who's in charge. Well, with a trust, the same thing. This is what I have, this is who it's going through to, and this is who's in charge. But a second step occurs with a trust that does not occur with a will. The second step is that during your lifetime, you, as the creator, you are transferring your assets into you as your living trust, meaning your house that you own. You retitle it out of your name and you put it into the name of your trust, your bank accounts, all of those assets that have your individual names, you transfer it out of your name and into the name of your trust. Or you name your trust as a beneficiary to receive your assets upon your death, like life insurance, for example. And then you, as trustee, you continue to manage those assets. It's business as usual, actually. No one has to know that you have a trust. And then when you pass away, your trustee then transfers those assets to your beneficiaries without having to go to court. And that's the main thing, that this happens without any court interference. During your lifetime, it's business as usual. You are in control, and your trust is amendable or revocable. It is merely a standby device. It just holds all of your stuff. It's sitting there quietly on a shelf or in a fireproof safe. But then in the event of your incapacity or your death, it springs into action without going to court. Number four, the number four reason or estate planning mistake is not protecting your beneficiaries from themselves. The cash people will receive from you is much more cash than you have right now. The cash people will receive from you is much more cash than you have right now. And I'll tell you why. In 85% of the cases, people will sell the family home when both parents die. That's a few $100,000. That life insurance, well, it matures at your death. That's another few $100,000, right? And then those antiques that you've been saving for generations and generations, we're gonna have an estate sale. All those cash accounts, those 401ks, those IRAs, those that you've been rolling over and saving, well, the IRS says that inherited IRAs are gone within 2 years from the date of death. So all of that, those cash that people will receive from you is much more cash than we have right now. Now, we need to ask ourselves, can they handle a big pile of cash all at once? So if they get that big cash a big pile of cash, how long does it take for a person to get their inheritance check and go to the luxury car dealership? 72 hours. So you may want to delay their receiving all that cash all at once. And the way to do that is through a living trust. Now, if you have any beneficiaries who are on this list, then you definitely need to get a living trust. The ones that are too young. Now, you're probably saying, wait a minute, you know, my child is old enough, but what does your will say? That your child, if they're deceased, does it go to their child who could be very young? And so if they're under 18, you need to make sure that their assets are protected. If they're elderly, ill, disabled, or have a drug problem. So if they're elderly or ill, and who would be able to manage for them? If they're receiving SSI or SDI, or they're on Medi-Cal, if they receive a whole bunch of cash, what will happen? The government's going to either kick them off or make them spend down their money, or in California, make them repay everything that the government has paid on their behalf for Medi-Cal. So what you do in this situation is you prepare what's called a supplemental needs-based trust, which will supplement their needs without risking their rights to their governmental needs-based assistance. If they have a drug or alcohol problem, clearly you don't want to give these people any money because it may exacerbate their problem. So what you do in this situation is you do what's called a general needs trust, where the trustee is still in charge of the assets, so they don't get it all at once. The trustee, you can give them special instructions that you will pay for their rehab, or they have to test clean and sober for 2 years before they get any of their inheritance, etc. You can set the rules of distribution. You just don't want to give it to them all at once. What if they're just not good at handling money? You give them $1 today and it's gone tomorrow. You want to preserve all of your legacy. You don't want it to be spent up at that luxury car dealership. So what you want to do is create a spendthrift trust for people that are not good at handling money. Or if they're not even working, you can tie their distributions to their W-2s at the end of the year. What you make will match your distribution to what you make every year. And if you set up trust like that, you want to make sure that the trust adapts to their change. Let's say that drug addict has now been rehabilitated for 10 years. Do you still want them to have to go do a drug test in order to get their money? That 18-year-old has gone now to college and they have their own family. Do you want to withhold their distributions? So you need to make sure that your trust will adapt to their changing needs. The number 3 reason, or I should say mistake, is not protecting your beneficiaries from third parties. Even if your beneficiary is capable of handling money, what if their spouse tries to take their inheritance at a divorce. Now, you're probably saying, Theresa, inheritance are separate property, and you're absolutely right. However, this is what happens in real life. You receive your inheritance, right? And then you start, taking family trips, and you start, building up on your home, or you purchase something together, and you're starting to slowly commingle those funds into your community property. And then soon as they're commingled, your spouse gets a fancy divorce attorney and demands half of your inheritance. And that is the number one way people lose their inheritance, is through a divorce. Another way is through bad luck creditors or bankruptcy. If they file bankruptcy within 2 years before or after receiving their inheritance, the bankruptcy trustee can take their inheritance. And that bad luck or creditors, if they, as soon as they get their hands on their inheritance, creditors can then come and attach their bank accounts, etc. Lawsuits, either valid or bogus. Remember I said that red bullseye? Well, someone just read my probate file, and they found out that my beneficiaries are receiving a whole bunch of money. They could go to my beneficiary's home, slip and fall, and therefore they can sue and get their inheritance. So your loved ones are not protected from third parties when they get their assets outright, without being protected in a trust. Or again, like I said earlier, Medi-Cal can force their inheritance to be paid over to Medi-Cal to reimburse, or to spend that inheritance down before they get any further benefits. And then if none of this is possible, then they could be subject to the possible second estate tax. Now, with Trump in office, estate taxes are pretty high. And so typically the average people do not have to worry about that. However, in 2027, it's going to go back down to its normal rates. But right now it's $11 million you can give to someone without worrying about taxes. But what I've been saying is that outright distributions is something of the past, even when your beneficiaries are capable of handling their own assets. Number two, top planning mistakes is failing to address what will happen when you are incapacitated. Now, we don't plan for incapacitation. We don't put on our calendar, okay, I'm going to slip and fall on this day and I'm going to hit my head and I'm never going to be able to handle my own affairs. We just don't think about it. However, if you look at the statistics on becoming incapacitated, it would be very startling, especially as we age. The possibility of becoming incapacitated and for that incapacity to last more than 1 year where we are unable to handle our affairs grows with each year. What happens when the CFO, the chief financial officer of the family, becomes incapacitated or passes away? I had 2 widows come into my office within 3 weeks of each other. And the husband was what I call the CFO of the family. He handled all the checks, the bill payments, all that. And they were at a loss when their husbands passed away. I always say, if you have a CFO of your family, is that once or twice a year, you reverse that and you become the CFO and you pay the bills. So if something happens, you know what to do in the event of incapacity or death. Is your power of attorney just a fill in the blank statutory forms? Those forms are very limited. You need a power of attorney that's expansive so that in the event of your incapacity, whoever you name can step into your shoes and start managing your affairs. Do you have the latest healthcare document? In California, we actually use 2 documents. We use a healthcare power of attorney and advanced healthcare directive. The healthcare power of attorney is very similar, excuse me, to the financial power of attorney, where that person steps into your shoes as a healthcare agent and advocates on your behalf. They're able to fire your doctors, they're able to hire your doctors or take your medical records to second and third opinions. They're able to take you out of the hospital if you want to go home and rehabilitate there, etc. That's your healthcare power of attorney. And then your advanced healthcare directive is for end of life decisions, when to withhold or start medical treatment. And so you want to make sure that that's updated. I tell my clients to pull it out the drawer every 18 to 36 months because our perspectives change, people in our lives change, and we want to make sure that it reflects what you currently want done. Powers of attorney and advanced healthcare directive. Like I said, powers of attorney, they give someone else authority to act on your behalf. In financial matters, they can do whatever you can do. I always say they could do what you could do, but better, and they don't need your permission. It's when you become incapacitated, if you meet the description or the definition of incapacitation, then your agent, whoever you name, they step into the shoes and they can act on your behalf. And then advanced healthcare directive, again, that's the living will. That's when I want to withhold medical treatment, or I want medical treatment, I want to stay alive as long as possible. But what these are, to me, these documents listed here, they are empowerment for your loved ones. They are empowered not only legally to do what you want them to do, but also emotionally, because they're stepping in your shoes and they're saying when to withhold medical treatment. And there's no guilt associated with those decisions, because actually all they're doing is giving voice to what you have already decided. They do not have to make those tough decisions on their own. The last mistake is you understand how important it is to properly take care of your estate plan, but you are too, now you put in the excuse. I'll wait till my taxes are done. I hear that a lot. I'll wait in the future. I'll wait till my children grow up. I'll wait some other day. Procrastination is the silent killer of estates. People who make these types of excuses, their estate ends up in probate, and that's unfortunate. So are you making any of these mistakes, or you want to avoid making these mistakes? Where do you go from here? And so you go from here by finding a good estate planning attorney. You can look them up on the internet, or the way I prefer is to get referrals from your trusted advisors. Look on those estate planning websites. See how long they've been doing it. Is that the only type of practice that they are practicing? What have they written? Is it clear and concise that you can understand? And then have a consultation with them. Go over your specifics. What I spoke about today is very general, but each estate plan, and I have never made the same estate plan twice, each person has their unique set of circumstances, and that so you need an estate planning attorney who can speak to your specific issues or problems, and so they can give clear and concise resolution to your problems or advice for your problems. And you also should consider, including your family after you've made your estate plan, including your family members to discuss your plans. And so therefore, there's no surprises when you pass away. And so now I would like to open up to questions, but I'm not sure how we will do this. I believe there's a chat box that you can now start asking the questions, and I will answer on them if we still have a little time.
This is Jennifer. If someone wants to ask a question, they can also unmute themselves. Please feel free to do so.
I have a question. I am almost 30. I have 2 young children. I just recently bought a house. I am a single mom, and I don't have much family who I would ever leave my things to. What are your recommendations in regards to, I am, one big part of it, I am a single mom. So I know that a lot of my, like my work things, I name like their dad, because I have been told that they're too young. If something were to happen to me, it would basically be, set to him because he's the guardian. What are your recommendations on that? Because I
Okay, yeah, I got it. But
bought a house and I'm just like, well, anything could happen within the next 16 years of my kids, not being of age.
So what I recommend is, of course, speak to an estate planning attorney. So this is just going to be a very high level, but a trust can work in your advantage. You can transfer your home into your trust, as well as name your trust as a beneficiary to receive those employer-related benefits. And that way, those employer-related benefits will be controlled by your trustee, and they can be used to help raise your children now, instead of when they receive the employer-related benefits either at their age of 18 or 21, depending on the contract. And so a trust can definitely solve or at least answer some of those concerns. Another thing is that you would want to, you can name someone as the guardian of the person of your children, as well as a different person as the guardian or the conservatorship of their assets. And so I always recommend that you name whoever you have named as your successor trustee as that person. Now, a successor trustee, or any agent for that matter, is someone who you can trust with your checkbook. It does not necessarily mean a family member, but it's someone that you can trust with your checkbook. And lastly, if there are plenty of families that do not have successor trustees that they can name, and unfortunately, people are now going to the public, and private fiduciaries. They're naming companies such as ACO or Edward Jones or Wells Fargo to be their successor trustee. And so if you don't have family members, then there are private fiduciaries out there. And I believe the Department of Consumer Affairs has a link on their website to private fiduciaries, because the private fiduciaries, they're licensed by the state of California, licensed and bonded. So I hope I answered your question. And so then I have a few questions in the chat. One is, what recourse do families have if a successor trustee does not follow the instructions in the trust? The family members can always open probate in regards to the trust. So the protections that the family members have initially is that upon the trust becoming irrevocable or the transfer of a trustee, then all of the beneficiaries that are listed in the trust are to receive a copy of the trust instrument. They are also supposed to receive an accounting yearly. So when the trust first becomes irrevocable, an initial accounting, and then every subsequent year thereafter that the trust exists. And so the beneficiaries are to hold that successor trustee accountable. And if the successor trustee is not following the rules or the instructions of the trust, then they can always file a petition with the court to open up probate in order to have the court then step in and either remove that trustee, make that trustee comply, or name someone else as a co-trustee. Now, the next question I have is, what is the price range on setting up a living trust? Now, I'm asked this question quite often, as you can know. And like I said earlier, that the trust, they are, I never designed one the same, but I can give you a range of of prices. So for a complete estate plan, which includes your trust, a will, and I'll go over why you will need a will even though you have a trust, powers of attorney, all the healthcare, the general power of attorney, all your other healthcare documents that are required, and the transfer of your assets from your name into the name of your trust it ranges for a single person, $2,400, to a married couple, which is about $2,800. And I do give discounts, such as if it's a referral, or if someone says that they were on this webinar, I will give a 10% discount. The next question is, recently someone asked me if they were responsible for their spouse's credit card debt if the debt was only in their name. So the thing, and I believe that's the same question twice. So beneficiaries are not responsible for the credit card debt. However, if the debt is considered a community debt, then the spouse is responsible for that debt. But if it's not considered a community debt, it was a debt that was made outside of the marriage, or it had not involved the community whatsoever, then that spouse is not responsible. Any other questions?
I have a question, and rather than write it out, I figured I'd say this. I have 3 children. They live across the nation. I live in Chicago area, and my son is here. I have a daughter in Pennsylvania. I have a daughter in California. So we're across the country. I have a will and the healthcare power of attorney and so forth. And I put all 3 of my children on my bank account. And had it stated in the will that whichever child I am with, when I become incapacitated, they would be the executor and take care of whatever I need. So would you give any advice or agreement on that?
Okay, so a couple of things. So you are under the Illinois law. And so I only can speak to California. I don't know if a trust-based plan or a will-based plan is best for Illinois. Now, if this situation was in California, this would be my recommendation, is that children should not be on your bank account. If you have your powers of attorney, if you don't have enough assets to have a trust-based plan and you have a will-based plan, then you have that power of attorney that if the event of your incapacitation, whoever you name as your agent can then step in and start managing your affairs. Now, you said your will included instruction for them to take care of you, and I believe you're saying while you were alive, if you are living with that said child. Now, a will here in California only takes place when you pass away. So that provision wouldn't work in a will here. Again, that's where if you don't have enough assets for a trust-based plan and you need a will-based plan, that's where those powers of attorney come in, not the check the box, the statutory kind, but the kind that it's thoughtfully written out so you can leave those types of instructions.
And I do have the power of attorney. I do have power of attorney.
Okay.
Stating that whoever I am with has the power when I become incapacitated. But as far as the bank accounts, you were saying you wouldn't advise that. I have well, how can I say this? I trust implicit all 3 of them because they are, okay, they work together with what they're doing for my good. So I don't have any reason to fear that they would do otherwise.
So it's not them, but it's third parties. If they go out there and hit someone and sued, that bank account is in jeopardy.
Right, okay. So the trust would be better.
If you were in California, that's what I would advise, a trust, and then name them as successor trustees.
Okay.
to either manage it when you're incapacitated or when you pass away. You may also want to look at or contact your financial institution and ask them if they have a specific special power of attorney. I know Wells Fargo has one here in California, as well as Chase has one here in California. I don't know about other states, but if they have their own special power of attorney, you want to get that. Complete it. You don't have to turn it in, but put it with the rest of your estate planning documents so that in the event of your incapacitation, there won't be very many roadblocks. And trust me, the banks try and make lots and lots of roadblocks, but there won't be very many roadblocks to prevent your children from acting on your behalf.
Great. Okay. Thank you.
You're welcome. Any other questions? Okay, I don't see any. Yes, I don't see any, Jennifer.
All right. Well, Theresa, you've been fabulous. We really, truly appreciate your sharing your information with us today and giving us some excellent tips to move forward. We encourage you, if you are interested, to give Ms. Geoffroy a call. And what is your information again, Theresa, in terms of your location and how they can contact you?
Thank you. I am at 9401 East Stockton Boulevard, Suite 145 in Elk Grove. My telephone number is 916-572-1998, extension 700. I am also available via the web at www.geoffroylaw.com. Geoffroy Law is spelled G like George, E, O like Oscar, F like Frank, R Robert, O Oscar, Y yellow, LAW.com.
Thank you. Okay, so if anyone is interested, we are having a seminar this afternoon for the Girls Summer Book Club. And I would really encourage you, if you're able to join us, to join us. It starts at 1 o'clock and it's headed by our one of our members who is a school teacher in the Elk Grove Unified School District, Sonia Stewart, and she's fabulous. We've set it up to be in different grades, but anyone who has children, grandchildren, nieces that may be interested in a summer reading program, we encourage you to join us this afternoon. And if you need further information on that, you may reach out to our Eventbrite space. Is this information showing up on the screen? I apologize. I thought I was screen sharing, but maybe I'm not.
Click on the actual slide.
Okay. There we go. Can you see that now? No?
And then
You need to do the put it on presentation mode and say start from that point, or you can scroll through.
I couldn't figure out how to get there, so.
Hey, Theresa, thank you for the information. It was really good.
Oh, thank you. I'm glad.
There it is. Okay, can you see
There
that?
you go.
Okay, thank you. So yeah, so our sections are set up for the 1st through the 12th grade. The meetings will be on the 27th of June, next Saturday, along with the 11th of July and the 1st of August. If you are interested in participating, you can register on our Eventbrite page, which is SacramentoNCBW.eventbrite.com. In addition, I wanted to also share that in the month of July, we're going to have a information to be shared regarding a Women's Black Health Initiative. And we will have a session scheduled Tuesday, July 14th. That has not been put up on Eventbrite, but it will be very soon. So we encourage you to join us for that as well. And we very much appreciate your being here this afternoon. Thank you so much for your attendance and your participation. Are there any further questions before I sound off? Unmute yourself if you need to say something, because I can't hear you otherwise. All right, again, thank you, Theresa, and everyone for your participation. You all take care.
Thank you.
All right.
Thank you. Thank you, everybody. Thanks, Theresa.
Thank you, Regina. Good seeing
You're welcome. Good seeing you. I'll give you a call.
Okay.
Bye-bye.
Bye-bye.